So real quick, I'm going to record this. Today I have a hearing, or I meet with attorneys in Florida for a uniform case management report. And the reason for this report is because I've submitted a complaint to the court in Florida to ask what happened to Khadijah, to my daughter, and also to um, to let them know that uh, my daughter was involved in a domestic violence dispute, and that's what I want to make sure we get this straight, and they let me know that this was not domestic violence. So I've filed with the court, so they're willing to hear my case in the federal court. So today I'm going to speak to lawyers so they can set up a uniform case management report so we can start the process to move forward to get answers to this domestic dispute issue that Khadijah was involved in and how she was killed. So I'm going to keep you guys on the computer, and I'm going to dial in right now. So it's going to be about 6 attorneys. So it's a shame I have to go through all this, but this is what us African American black mothers, fathers, parents, we have to go through in order to get answers as to what happened to our child. It's a shame, you know. Something can't be right if we have to go through all of this in order to get simple answers as to what happened to our child. And to try to even tell them that it was domestic violence, and they don't listen. You know, Biden just passed a law for violence against women, but this is why it continues, because everything is supposed to get pushed under the rug. Or you're supposed to be afraid to confront it as a parent. But you have to confront it. You raise your children, you have to confront this kind of stuff. Otherwise, you will never rest. You just will not rest. Let me see. It says, join the planning conference. Dial 1-800-800-800-747-5150. Now, this is the federal court that I'm calling right now. Or it might be the office, the attorney's office, so we can, and I'm pretty much not going to argue about anything. I'm going to let them set their dates for whatever they want.
Access by Lumen. Please enter your access code followed by the pound sign. Thank you. Please stand by. You will now be placed into conference.
Right now, so I can make sure we know it for the report.
Hi, Ellie. It's Ivy Rollins.
Hello.
Hi, Ellie. Bradley Muse.
Jen.
This is Ranger Jackson with Batavia Ross Nicholas McQuaid.
Okay.
Belinda Wood, mother of Khadijah Hamadullah Wood, minor.
Hi, Good. Mr. Jackson, is your first name, is it R or B?
Yes, it's D. First initial is D. Middle name is Ranger Jackson.
Got it.
I'm an attorney. I work with Aubrey. I'm not sure if he's on or he's going to make it.
Got it. So, and I think that Bradley, you're standing in for, because Bridget is not going to also be attending. Is that correct?
I'm sorry, what was that name you just provided?
Oh, Bridget, we're not waiting for Bridget. She's not attending today as well. Is that correct?
I think she's going to try to call in and listen in, but I'm going to be handling it on my first side.
Hey, should we give Aubrey another couple seconds, or do you think we're good?
No, we can just proceed. We can just proceed. That's fine.
Okay, great. So, Ms. Wood, we had, per like the email exchanges, we had set up this call to discuss the issues that we need to address in a report, management report that the judge is requiring us to file. It's due today, so we're gonna kind of walk through that report. The roll call I just went through, just so you know, it's the attorneys for all of the defendants who have appeared at the case. Everybody's present. So there are a couple defendants that have multiple attorneys from the same firm, but there's at least one attorney for all the defendants present, and that'll be stated. I took a note of them, and it'll be in the report that I'll circulate. So the report that I sent is just a draft, just for discussion purposes, and it is using the form that we're required to use, which is posted on the judge's webpage. That's the civil action order that I attached to my email today. That's the one that says that we have to go to the webpage and use that form. So it's kind of a fill in the blank case management report that we go through, we fill in with the information that's required, and you'll see the bulk of it is this table that in section 2 that has deadlines and dates, and the table has the corresponding table for just the general parameters for all of these deadlines on the judge's webpage. So that was the third document I attached to my email, was just I printed it to PDF, the judge's preferences on his webpage that have the table that provides the normal parameters, guidelines for setting the date in this order that we're going to discuss. So I think that's kind of the introduction. Before we, get started, maybe going through the report, do you, Ms. Wood, have anything that you want to discuss as a preliminary matter?
No.
Does anybody else in the defense counsel have anything, or are we ready to jump into the report?
Nothing to add.
Great.
Nothing to add.
Okay, please, everybody, Ms. Wood included, please feel free to interrupt at any time. So Ms. Wood, were you able to open the draft that I sent?
I have it here in front of me.
Oh, okay, great. So what we did was, the first part is pretty self-explanatory. We have the date and the means by which we're holding this conference right here, and listing the people who are attending. I've just added Mr. Jackson because I did not originally have him listed. So moving to the bulk of it, which starts with section 2, the deadlines and dates. Okay, so if you see the parameters from the judge's website that I attached, the table there, some things it has just like a date certain, something, a number of days, and then some of the periods are like erased. like 4 to 5 months from whatever date. So all of the deadlines and dates in this draft that I have here are using the judge's parameters from his webpage, except for one. And that is the first one, the deadline for providing mandatory initial disclosures. And the rule there cited that requires this exchange of what's called initial disclosures. Usually it is going to, the deadline is going to be 2 weeks from the date of our conference. And so the deadline that we have there is a little bit longer than usual. And that is, let me just double check. Yes, that is the only date where you have longer than the 2 weeks that is generally provided. And so just want to see if anybody has any issue with that. And I guess we can start with this would. The time period is, I guess that the reasons for that was that we would have more time, given that there was a little bit of, some procedural, stuff, at the outset of the, the case. There's the case was removed from state court to this court. There's pending motions relating to that, whether the case is properly removed. You filed a motion directed to that, so we have that, and then we have had an amended complaint filed. So that's the reason that we, or I guess I'm not going to speak for everybody, that I put the longer time period. So I guess we can open the floor to thoughts on that, and it's mutual, Ms. Wood. It's everybody, all the parties need to provide those additional disclosures under the rule that's cited there.
That's fine.
Okay.
I'm in agreement with that date. This is Ivy Rollins.
Okay.
This is Ranger Jackson. I'm in agreement. We're in agreement. So is Leslie.
Okay. Okay, so if everybody's okay with that, we will pencil that in our report for the May 2nd deadline. And then there's, which section of it is? In the, that also covers section, there's one section that asks for if there's a departure from any of the time periods, and for some reason now I cannot find it. Oh, it's the discovery plan. It's in section 9 on page 4. It has a couple subparts, and subpart A says that the parties agree to the timing, form, requirements, and disclosures. And so we checked based on that proposed May 2nd date, I clicked no, that instead we'd agreed to the deadline for initial disclosures would be May 2nd, 2022. So that addresses that departure. And then I guess going back to the table, sorry to drag everybody back and forth. So all the other time periods are, from the parameters. Most of them go to the starting place is kind of figured out going, Ms. Wood, the judge's online calendar is kind of what dictates some of these deadlines, is that we have to go, had to go to the judge's website to see the very last line on this table where it says the month and year of the trial term. And the time period, I believe it's 10 months, and that is the closest, and we look to the closest trial term that the judge has on his calendar for 2023. I'm sorry, not 10 months. I'm sorry, it was 20 to 22 months. And then the date is provided there. So I didn't choose the November 1st date. It was the product of the 20 to 22 month period, and then looking at the judge's calendar for that year. And then kind of go backwards to compute the deadlines starting from there. So the parameters that I provided from the judge's website, they have the date of the pretrial conference is calculated backwards from that by a number of days, and then the deadline for filing the pretrial statement, et cetera. So that's kind of how it's a little bit, it always gives me a little bit of a headache to go back and forth, so I'm not really explaining it very clearly, but the starting place is kind of at the end, and then we use the date, the deadlines of the time periods and the parameters to kind of move up the table. So, does anybody have any comments, questions? Want to discuss any of those?
No comments. This is Ms. Wood.
No, no comments from Ms. Rollins either.
Okay, great. Thank you so much. Just writing everything down. Okay. And so then we have indicated an estimate right below the table of approximately 5 days for the trial, and that it's a jury trial. The estimated trial date, a number of days for trial is usually just that kind of at this stage of the case. Just an estimate. So if you have any comments to that, Ms. Wood, or any of the other parties, we can.
No comments. This is Ms. Wood.
Okay, moving on to the description of the action. Ms. Wood, I don't know if you've had a chance to look at that, but the language is what we used in the original draft that we had sent you, and then we filed on behalf of the defendants, which is being replaced by this, but this was the language that we took from that, which describes the nature of the claims, and it's just in general terms, it's just a summary. So I don't know if you have any objection to any characterization of the claims, or if you agree that it's accurate.
I read it. I don't have any comments about it.
Okay. And I believe that all the defense counsel have already seen that. If I'm wrong, let me know. I don't want to speak for all the defense counsel, but a number of these items that we already had gotten your guys' input on. So I will kind of go through them, and if you guys have objections to anything, just let me know. But moving on to the number 4, so the disclosure statement. So this one is whether we couldn't check the box saying that all parties have filed this disclosure statement. All the defendants have. You can look at the rule that is there in Section 4 of the local rule 3.03, which talks about doing a disclosure statement of interested persons. And so you can look at that and determine what you would like to file in that. But I don't really think, we don't really have any input in terms of what you put in there. The defense already filed theirs. Something that you file on your own.
Okay.
Okay. Okay. Okay, so moving on to 5, we did the notices. The defendants, the attorneys, at the time they filed their notices of appearances, did the notices of related actions which were required by the rule. We had noted the prior case, the one that you filed in the Middle District of Florida in the fall of 2021. So those were that case was disclosed. I'm not aware of any other case. I don't know if anybody else is, or Ms. Wood, if there are any other cases beyond what we have filed, but you can look at that rule and provide any additional disclosure and compliance with the rule if there are any other cases, any relating action. Okay. Okay. So number 6 is consent to a magistrate judge. So it's not the I guess the judges, the district judge that we have assigned as magistrate judges, which are not full district court judges, but they help them out by handling some cases. There are certain things that can get assigned to a magistrate judge in this wood that you don't really get an option. The district judge can have them sent to the magistrate judge, or the magistrate to issue like a recommended order, and then the district judge enters ruling. This here is asking us, the parties want to consent to have magistrate preside over the proceedings in this case as a whole. And so we have 2 options: either the parties, which would be all parties, you and all the defendants, consent, or the parties do not. And I speaking for the defendants that I represent, and I believe the other defendants' counsel expressed the same, that we would not want to consent to the magistrate overseeing this case. So it just takes kind of that off the discussion, because we need to have unanimous consent for that one. Okay. So now, moving on to number 7, the preliminary pretrial conference. We have the option of whether we wanted to request one before the court actually enters the scheduling order, or not. We had decided in discussing this with the defendant's attorneys that it would probably be helpful to have a preliminary pretrial conference, and one of the, I think the reasons would be the number of parties in this case. Might be helpful to have everybody together in a conference, and also that you are not represented by an attorney. That might help have everything clear on your end, and kind of make sure that everything goes as smoothly as possible. So those are the reasons that we thought it would be helpful to have a conference. But please let us know if you have any thoughts on that.
That's fine. We could do that.
Okay. So discovery. This is just confirming that we have to comply with our duty under the local rules, that we have to, before we file motions, we have to follow that rule, that local rule 3.01, and confer with the other parties, and indicate try to resolve disputes about discovery and other motions, and indicate in the in filings the things that rule requires us to tell the court to show that we comply with that. So this is just to confirm that we'll comply with it. You can read the rule, the local rule there, and there's also I believe it's on the same page as the local rules, or it's in the same area. There's a discovery manual or procedure, I forget what it's called, up in the Middle District of Florida. That's the second document that's referenced there if you want to find it. It's on the court's website. Okay. So the discovery plan, we just discussed this, the only one that we modified for Part A of Section 9 is the decommissional disclosures. So I covered that. For B, discovery might be needed on B subjects. It's kind of broad. It just says that to the extent that the claims that you have in your complaint, proceed discovery on those claims, and if the defendants are required to respond to those claims by filing an answer and raise an affirmative defenses, that discovery would be related to the issues that the defendants would raise in their answer and affirmative defenses as well. So it's kind of broad, but that's just the general scope of discovery is, the claims and the defenses. So, do you have any input on that, Ms. Wood?
No. I don't have any input on that. This is Ms. Wood.
Okay. For Part B, we didn't think there was need to do discovery in phases. I think that the conducting discovery phases would be kind of an exception to the norm. So we didn't think that there was a need to depart from the ordinary course of discovery under the rules of procedure and the local rules. Any disagreement with that? Okay. Same goes for for D. We didn't think that there was any particular issues, at least at this time, that we anticipate relating to the discovery of electronically stored information that would require getting together and trying to resolve or anticipate how to deal with electronic information at the outset. Again, this is kind of a something that would be geared towards, I think, more complicated cases that have, I'm not saying this is not complicated in terms of the claims. I mean, in terms of the volume of information that might be out there in an electronic format. So we don't really anticipate any issues at this time, but if we do, Ms. Wood, we can indicate in that section. Okay. So E, again, this one's about the privilege and work product issues, and we did not think there was anything kind of unique that would require us to go to either have some sort of agreement for how to deal with these issues relating to privilege. Usually it's maybe there's a whole bunch of discovery of electronic information, and that the parties don't want to go through each document or each page or item to determine whether or not it's privileged. We don't see anything that would require that step here. At least at that time, that's something we could always do if there were an issue arising. Sure. Okay. And so it stipulates the change in limitations on discovery. We just thought that the default of what discovery is allowed under the federal rules of procedure is fine, that there would be no limitation other than just what is within the scope of the rules. That's okay. And then on 10, do not want to see need for any special handling of the case. I've actually never had a report where has anybody a defense counsel, has anybody had a request for special handling? I don't even know the types of things that would be in there, actually, now that I'm thinking about it.
Yeah, I have.
Yeah, what kinds of things go in there? Miscellaneous? Okay. Yeah, so unless somebody thinks this may be something that I haven't thought of, we just put the indicated no. And then finally that we would, in 11, that we would certify that we've read and are familiar with the court's local rules. Several of the rules were, cited in this report. They are on the court's website. There are a lot of them. There are a lot of them. There's also the discovery manual. I forget what it's called, the procedures on the court's website. And then, so those are things that just apply to the special things that have to apply to this court. And then there are also some things just for your reference, like on the judge's website, for his particular procedures and policies. Well, like we got this form for the case manager report from the judge's website. So those are the things that we're supposed to certify that we're familiar with, the local rules, and that we're gonna abide by them.
I do have one question. I do have one question. Your number 4, your disclosure statement, what date did you file that?
I'm sorry?
Your number 4, the disclosure statements, what date did you all file that?
Okay, so let me pull this up really quickly, just one second. There were a few different ones because the defendants filed them separately through their separate counsel. So we have the medical examiner, Dr. Wilson, etc. Their certificate of interested persons was filed on January 14th. The lifelink was filed on the 14th, and I believe the cities was on the 18th, as well as the 2 of the detectives, Cook and it was Cook and Lance, and then Jill Frears was on the 28th. And then on the 31st of January, I think that was the one, the Attorney General's office filed theirs on behalf of the 2 persons that they represent for California and Douglas Ellis.
Okay. Thank you.
So, I've gone over does anybody else, Ms. Wood or any defense counsel, does anybody have any comments or anything that we want to change or address in the report before we put it in final? Okay.
No, I think the only thing, just because I'm attending, we may need to add my name and into the signature block.
Okay. Yeah. Well, you'll be the one signing instead of Aubrey.
Well, I guess Aubrey, Aubrey can sign, it's just that I'm here, so that's fine.
Okay, yeah, see today. So I think the way that we're doing is we're telling me that I'm authorized to type people's signatures. Let me just, while I have it up, let me just add you really quickly so I don't forget.
Yeah, and then my email address, I don't know that I necessarily need to file in on the case or anything like that, but if you want to put my email address at the bottom as well, it's RJACK in the same format as the rest of them, so RJACK and then at @erdlaw.com.
Okay. Okay, so I added that to the signature block. Anybody else see anything? So So, is everybody okay with the signatures and the type S-S type name is I guess we'll start with the defense counsel. So is everybody who's here okay for me typing their name on behalf of their respective clients on the signature block?
Yes.
Okay, and okay, and so Ms. Wood, are you in a place where you would be able to sign and scan a signature page to me today, or send me an email? Alternatively, either send me an email saying that I'm authorized to type your name on the signature, in the way that I've done it for the defense counsel. You can pull up any of their pleadings and typing.
That's fine. I'll send you an email.
I'm sorry?
I will send you an email.
Oh, okay, great. Okay, so I will do that. I will just go ahead and send this report, and I'll send it right now, and if people could just scan through it and just send me a reply that, yes, authorized, good to go, and I will take everybody's signatures and get it filed. And with that, I think that, I finished. That's everything that I had planned. I don't know if we're overlooking anything, but so I'll turn the floor over to anybody else who has anything.
Hi, this is Bradley. The only thing I have is whenever I was trying to hit unmute, I accidentally hit hang up. So
Sorry.
I appeared there for a second, but did anything happen after you asked if people would consent to you putting their names on?
I don't think so. I just said we're going to go through, and I'm going to send the report and to you guys by email, and just ask everybody to reply, and then I'll just take everybody's signature and file it today, because we have a filing deadline. I'm going to send it right after we literally right after we hang up, and if everybody can just be sitting kind of by their email and do it so we can actually get it filed, that'd be great. I don't have to get legal today, so I want to allow a little bit of time for me to file, because I'm not as good as she is.
Perfect. All right, thank you.
Sounds good. Thank you very much, Ellie.
Thank you so much. Thank you, everybody, for your time. I know it's late on a Friday, so thank you so much. I will get this out to you guys in literally 2 seconds.
Thank you.
Okay, so what just went on there? That was the Uniform Management Report. And so I am going to present my case to these attorneys. And that's it. And thanks for hanging out with me for 38 minutes. That was pretty long, but I appreciate y'all watching and listening. And have a good day. I'm Khadijah Wood's mom. And thanks for watching.